for Tabernacles. We should be back next week. Let's open with prayer. Dear Lord, we ask your blessing upon this meeting, upon the message that is coming to the people tonight. We hope that you will both inspire the speaker and those people listening so that we may take those lessons out of what we study tonight for all of our benefit to follow your law. We ask this in your Son, Yahushua's name. Amen. Okay, is there any announcements that we have this evening? No announcements? Okay. I believe this past weekend, Victoria was in Florida and doing a seminar, I believe at West Palm Beach. Coming down in the next month, she will have a seminar in San Francisco. She will also have another seminar in San Antonio, Texas. And from what we mentioned last week, the San Antonio seminar is in danger of not occurring unless people in Texas or in those areas down there start signing up. And these are very, very good lessons, good material. Victoria keeps calling me all the time with people that are using this material in their cases and doing quite well. I'm not going to put the name on the tape, but I will tell you that I have talked about this party in the last 3 months. This party had gone to a sentencing. It looked like things were somewhat hopeless. That party has now been redrafted by the court and the prosecutor pursuant to the rules of post-sentencing conviction. They're going to drop the sentence that put him in prison, and they're going to come back for a total resentencing. If you don't believe that this material is not working and is not effective, then you don't have a clue of what is going on. As I was talking to some of the people helping this party, I said I believe quite strongly that one of the main reasons why this is occurring is literally because this particular party has shown honor. He has been continuing to work to settle the accounts behind the scenes even after the sentencing. This party has not been charging or accusing any public officials for violating any laws, for violating any rights or anything else. And it so far is going beautifully. New paragraph. I have gotten a couple of emails and information from some different sources that we will probably cover somewhat tonight. And part of this is indeed going right along with most everything that we have been learning. I got an email from Nick Groshinen out west that he passed this on from some other party. How many people in here have heard of a patriot who has put out a course and I believe goes by the name Mike Brown? Anybody ever hear of his? Yeah, there he has several people in here that have been in the Patriot movement for more than probably 3-4 years. Brown had a cookbook out on procedure. He's taught procedure for a long time. I believe he is probably the author of the major message that is behind the context or the subjects in this email. And my purpose in going through this tonight is because it absolutely is an absolute second witness to what we've been talking about in terms of procedures either in the civil or criminal courts. Remember that we have basically been outlining the concept that the facts are irrelevant in any of these proceedings. We have further outlined the concept that you have to have settled the issue on the private side before you go into the trial or the public court hearings. We have also talked about the fact that the judges, the prosecutors, and the attorneys are operating as fiduciaries in these tribunals in order to obtain equity for the parties that deserve equity and to put equity against parties that have acted dishonorably so that they do not get the remedy if they do not understand what the whole concept of honor-dishonor is about. So consequently, this article is entitled The Secret Courts. Secret Law, and it's supposedly by a Larry Boland. And like I said, the one who had this on either an email site or something was Mike Brown. And I'll give you Mike's website. It's www.mikebrownsolutions.com. Everything lowercase, everything run together. And this was an HTM article off of that website, www.mikebrownsolutions.com/secret.htm. It says here, for your information, what conclusions may we draw from this latest foray into legal slime? Public trials are a fantasy. There is no meaningful access to the courts. Due process is a distant memory. The Star Chamber proceedings, which caused our forefathers to leave England in the 17th century and land in Massachusetts, apparently stowed away like rodents and invaded this country, and today continue to eat away at the very roots of an increasingly dysfunctional judicial system. That was a quote from this website. Secret Courts, Secret Law by Larry Boland. The traditional Anglo-American distrust for secret trials has been variously ascribed to the notorious use of this practice by the Spanish Inquisition, to the excesses of the English court of Star Chamber, and to the French monarchy's abuse of the letters de cachet. All of these institutions obviously symbolized a menace to liberty. In the hands of despotic groups, each of them had become an instrument for the suppression of political and religious heresies in ruthless disregard of the right of an accused to a fair trial. In re Oliver, 333 U.S. 257, or 68 Supreme Court 499, a 1948 case. New paragraph. Some authorities have said that trials in the Star Chamber were public, but that witnesses against the accused were examined privately with no opportunity for him, the one on trial, to discredit them. Apparently, all authorities agree that the accused himself was grilled in secret, often tortured, in an effort to obtain a confession, and that the most objectionable of the Star Chamber's practices was its asserted prerogative to disregard the common law rules of criminal procedure when the occasion demanded. That comes from a history of English law and the Court of Star Chamber, 12 American Law Review 21, at page 25 through 31. Secret law is an abomination, wrote Professor Kenneth Davis in Administrative Law Treatise 137 in 1970. This quote has been cited in numerous federal cases involving Freedom of Information Act requests. Two of these cases, Cox v. United States Department of Justice, 576, Fed 2nd, 1302, and Stokes v. Brennan, 476, Fed 2nd, 699, are just two examples where the courts argued that secret law is wrong and government agencies, which the courts are to make their documents available for public inspection. It is crucial to public confidence in the courts that judges be seen as enforcing the law and obeying it themselves. Notice the word confidence is itself a confidence scheme. New paragraph. Sounds good so far, except when it comes to cases concerning those, quote, evil Arab terrorists, unquote, and the Immigration and Naturalization Service. In 1996, the President signed the Anti-Terrorism and Effective Death Penalty Act, which authorized secret evidence. A federal district judge in Newark, New Jersey, William Walls, has now described this as government processes initiated and prosecuted in darkness. The rest of us, Congress, created Congress created two little-known bureaucracies, which are responsible for the kind of justice that all thinking free people have come to dread. One of the organizations created in 1922, albeit under a different name, was the Judicial Conference. In 1939, Congress transferred responsibility for federal court budget preparation, data gathering, and administrative support from the Justice Department to the newly created Administrative Office of the U.S. Courts, which was directed to function under the Judicial Conference supervision. See the Chamber's Handbook of Judges, Law Clerks, and Secretaries, hereinafter the Handbook. The Chief Justice of the Supreme Court presides over the Judicial Conference, which is composed of the Chief Judge of the Court of International Trade. Although Congress has vested relatively little authority directly in the Judicial Conference, this organization has considerable practical authority. That authority arises from its statutory responsibility to supervise and direct the administrative office of the U.S. courts, including the administrative office's control of the distributions of funds appropriated by Congress. People with a modicum of intelligence have already figured out that the Judicial Conference controls the federal courts. In 1967, Congress created the second pillar of injustice and labeled it the Federal Judicial Center, hereinafter FJC, at the request of the Judicial Conference. The FJC's mission is, quote, to further the development and adoption of improved judicial administration, unquote, in the courts of the United States. The Center's statutory duties are codified at 28 United States Code, sections 620 through 629. They include providing orientation and continuing education for the judges and staff, which includes judicial law clerks and secretaries of the federal judicial system, performing research on court operations and procedures, particularly in support of judicial conference committees, and conducting programs to promote judicial federalism, assist foreign judicial systems, and study the federal court's history. New paragraph. Governance of the Center consists of the Chief Justice of the United States, who chairs the Center's board, which also includes 2 circuit judges, 3 district judges, 1 bankruptcy judge, and 1 magistrate judge elected by the Judicial Conference, as well as the director, who oversees the FJC's activities, and its members, who serve on standing committees on education and research and on Center advisory committees on judicial education programs. Now the issues at hand. Secret courts, secret law. New paragraph. One of the more interesting publications the educational arm of the federal courts has produced in recent years is, quote, a guide to the preservation of federal judges' papers, unquote, 1996, hereinafter called The Guide. Just as the title suggests, this concerns the preservation of judges' papers. However, this is another little gem found in this book. What this piece of work contains is absolute proof that there are 2 types of justice. To deviate from the writing in this paper for a minute, the point that I want to reach at covering this document today is that we have already talked about the fact that everything that goes on the public side of the courts is really a mirror of what's happening on the private side. That the true work of the court is on the private side of the court. And that however the private side of the court has determined the matter is going to be disposed of, will then reflect on the actions on the public side of the court. How the case seems to progress, what goes on, and what the ultimate disposition of that court case is going to be. And we have said time and time again in the last 4 to 5 months that it barely relates to the actual facts in the case, which are irrelevant most of the time. So as we go on with this paper that was written or composed by patriots to condemn allegedly the acts and actions of these courts, I want you to listen with an open mind, because in supposedly condemning these courts for not allowing, quote, fair and good public trials, unquote, the presumption of the authors of this patriotic paper are these courts are operating in secret, and they're a fraud, and they are a bad thing on society. Whereas if you listen to exactly what the patriots are telling you and read between the lines, you will see that what they're saying is that, yes, there is 2 courts here. There's 2 types of justice. And they're lamenting the fact that what's going on in public doesn't appear to be in harmony with what they'd want it to be. And they're very upset that there's a private side to the court which they can't reach and get at, and it appears to be a lot more important than the public side of the proceedings of that court. And if they could only understand what was truly going on here, they would definitely see that they're trying too hard to get their remedy on the public side of the court, which gives them no remedy. They ought to be using what they've observed, all of the power on the private side of the court, to get the remedy they're looking for. Let's go back to the text. Despite what you may think, there is one type of justice for the rich and another for the poor. However, the brand of justice this publication discusses is private versus public. Aha! They have that right, don't they? Our own modern-day Star Chamber, only it is more sophisticated and is found in every federal courthouse throughout this country. I'm surprised they haven't observed that it's also in the state, county, and local courthouses. Everyone who becomes involved in a federal case, civil or criminal, rich or poor, black, white, yellow, or brown, will be treated in a way this man with hair now white would have considered impossible just 5 years ago. That's the author of this piece lamenting what he sees as a dastardly Star Chamber court proceedings that won't give him any remedy because he can't get to the private side of the court, he assumes. New paragraph. As the old saying goes, the proof is in the pudding. In the federal courts today, we have two sets of books. One set, the official record for public consumption, will be handed to you by the clerk from behind the counter at the federal courthouse for a fee of copying, of course. As was described by the Federal Judicial History Office, quote, the official court record and its focus on formal, meaning public, procedures does not reflect the full complexity of the judicial process and the work of individual jurists, unquote. What's he talking about? Private letter rogatories, other things going on that never hits the public record? You bet. See, if these people don't understand that you've got to operate on your case privately behind the scenes, then they just assume and presume that the only one operating privately are the officials from the government, which for those people, that's probably all that's putting anything in that private record. Therefore, these patriots feel that the case procedure is stacked against them, a fraud, and impossible to get a remedy, rather than understanding what the true procedure and remedy is for getting your remedy is to use that private side. That came from the guide at page 3. Pray tell, where is that record that contains the full measure of the judicial process? Our hero asks. It is a record that lowly litigants will never see, he laments. That record is found in the star chambers of the 21st century, the judges' chambers. The guide describes this record as, quote, chambers, papers, unquote. Notice that what this author is doing is he has researched and he's describing from the government people who were appointed by Congress to run the federal courts, and he is second witnessing exactly what we've been telling you all along. but he's upset about those documents and papers. And as far as I'm concerned, I am absolutely thrilled that he is second witnessing exactly what's going on here. Because we are accessing and using that process as those people should be doing themselves. New paragraph. Chambers' papers reveal the challenge and difficulty of the judicial trade more clearly than official case files by helping to explain the internal work of the federal courts and the process of judicial deliberation. Chamber papers also describe exchanges between the bench and the bar and the relationship between the court and the community in ways that published opinions and official case files cannot. The guide, page 3. In other words, those secret details or those secret deals between judges and lawyers about which we have read and heard take place in the judge's chambers. Isn't the judge's chambers private law? Isn't that common law? Isn't that what the patriots have been trying to reach? Why are they so upset now that they found out the courts are actually doing it? Duh. This is the same radical conspiratorial group, 2 scoops short of a full load, espousing this thinking on some obscure website. This publication is written with approval by the very bar members themselves and published under the auspices of the United States government. So once again, aren't they telling you exactly what they're doing? So why is it a secret Star Chamber proceeding? New paragraph. These chamber papers must be very important if they are not public information. You bet that's how the case is being decided. Just what sort of data do these records hold that cannot be revealed? i.e., the basis of all the court decisions. Chambers papers frequently include pre-decisional material, such as draft memorandum, like letter rogatories, aren't those drafts to the parties of the court? Draft opinions, orders, correspondence, and research. Often included among Chambers papers are documents relating to the administration of courts or justice. The guide, page 3. Material so important that it is only handled by confidential employees of the court, aka judicial law clerks, he says college kids, and secretaries. That's from the American Bar Association, Standards Relating to Court Organization, page 99, 1990 publication. New paragraph. If you desire to open the vault containing the information that really decided your case, forget it. As it stands now, the Chief Justice, although the administrative officer of each court, will simply ignore any and all Freedom of Information Act requests. A letter your humble author addressed to Chief Judge Lanier Anderson of the 11th Circuit Court of Appeals did not even elicit a response. The communication requested information such as the name of all individuals who prepared any and all bench memos, draft memorandum, draft opinion, orders, correspondence, and who had conducted other research relative to cases filed with the 11th Circuit. My letter was ignored. After waiting several weeks, I phoned the Office of Appeals and was informed that any such FOIA request should be addressed to the clerk of the court. Why the clerk? Yeah, clerk's the holder in due course of all the documents in the files. The clerk's answer to the same FOIA request made to the chief judge stated that FOIA, quote, does not apply to federal courts, unquote, citing 5 United States Code, Section 551, subparen 1, subparen B. 5 U.S.C. Section 552, subparen F, subparen 1 as the basis for his decision. He's absolutely right. Courts are immune. It's an administrative process, supposedly not judicial. What conclusions may we draw from this latest foray into legal slime? Public trials are a fantasy. That's a true fact. There is no meaningful access to the courts on the public side. That's a true fact. Due process is a distant memory. Not true if you use your private administrative process first. The Star Chamber proceedings, which caused our forefathers to leave England in the 17th century and land in Massachusetts, apparently stowed away like rodents and invaded this country, and today continue to eat away at the very roots of an increasingly dysfunctional judicial system. 2001 publication. You can find it on the MikeBrownSolutions.com website. So what this guy is lamenting is the fact that the public side of the court gives nobody a remedy. What else is new? We've known that for a long time. The issue is, does he understand that the private side gives you a remedy, and that's what he was referring to? I don't think he understands it at all. I talked to Nick this morning, and Nick said that he got a call from someone that was in prison. And this guy is studying a lot of this process, the commercial process, the redemption process. And a lot of people that study it come up with all kinds of knowledge about either the history of what's going on or the procedure of what's going on. And their instant reaction is, good, we're going to go in and we're going to use this, this, and this against them, and that's going to stop them. Isn't that just more warfare? Now remember, in the Old Testament book of the prophets, where they talked about the concept of the wood yoke and the iron yoke, they said that when the Father puts a wood yoke on us, in order that He will test us and put us into a debt and into a punishment for a season of time until we learn our lesson and repent, that if you try to throw that wood yoke off too quickly, that what will happen is the Father in heaven will create circumstances whereby all of a sudden someone is going to show up and substitute an iron yoke for the wood yoke, presumably a yoke or a servitude that you're not going to be able to remove as easily as one would remove a wood yoke. So as Nick was talking to this gentleman, the guy said, hey, don't you think I figured this out? Can't we go in and stop them? And Nick, not to be just frivolous or not just to poke a hole in a guy's balloon, but to make him sit back and take cognizance of the bigger picture, the one I just explained to you, he said to this gentleman on the phone, he said, would you take a half a minute while you're on the phone with me and just look around you and describe to me what you see all around you? And the guy came back and he said, well, there's a lot of people locked up here. And Nick said, aren't you surrounded by iron? And the guy said, yes. Nick said, well, let me tell you what I see from where I am. I'm here in my house, and I'm surrounded by a lot of wood. And Nick said, I've been studying this process for a long time also now, maybe not as long as you, but I have been studying this process for a long time, and I went out and I thought I understood a number of things and started doing a number of things, and it looked like for a time that I might be substituting my wood yoke that I'm under right now for an iron yoke also. But because of a blessing of the Father, I'm still surrounded by the wood yoke instead of an iron yoke like many patriots today are. Then Nick said, I'm not interested in trying to throw off this wood yoke that the Father has placed on me right now until it is an appropriate time. And so I'm not studying all of this material so that I can go out there and go into their courts and use all of this material so that I can show them I'm at liberty and I'm going to throw off my wood yoke. Because if it's not time in the Father's kingdom for me to be losing this wood yoke, I might just be substituting an iron yoke in its place. And so the whole concept comes down that certainly these so-called star chamber tribunals are a form of a courtroom which is basically a wood yoke surrounding those people summoned in there. And if the people going into those star chamber proceedings do not understand what's involved here, they might just very well be exchanging that wood yoke of those star chamber proceedings for an iron yoke of a jail cell because of their dishonor. The biggest trouble with the patriot community is they feel they have to go to war and they have to fight an enemy. As the old adage says, we have met the enemy, and it is us. It is ourselves or the reflections of ourselves that we are fighting. We are not fighting the government officials. We're not fighting the bankers. We're not fighting the lawyers. They're merely providing us the arena so that we can go in and beat ourselves up unless we start understanding what is happening here and getting a clue. Now, many of you probably know that Roger Elvick has been arrested. This occurred probably about 3 weeks or so ago, maybe even sooner than that, a month or more. And I have been privy to several emails that have come to me involving some communications that people have had with Elvick since he has been arrested. And to my knowledge, right now, he is still up in, I believe, Minnesota or Wisconsin, wherever he was arrested, although he is supposed to be under a governor's warrant to be transferred to the Cleveland, Ohio area here. And in the documents which Elvick has sent out to some people, I have no knowledge that these were totally private and could not be used. I know they're passed around on the internet. There are some interesting facts that have come out of these. And it's interesting to see where it is that Elvik himself is going in some of this material. He talks philosophically about a lot of the signs and a lot of the facts which are indicia to his arrest. And for our purposes here tonight, that's not basically the subject matter of what we want to get into, so I'm not going to read these verbatim. But Roger was not the only one arrested, because Ron was arrested, and so was another gentleman, Tom. We won't use last name. And it appears as though the public issue as to why they were arrested was their filling out of 8,300 forms to the IRS. So if anybody is spreading rumors like, oh my goodness, Roger's been arrested because everything he's been doing, like writing checks on closed accounts, or asset money, or drafts, or anything like that, that does not appear to be the public issue behind the so-called arrest. Understand this. It's supposedly going to come out of an indictment in Cleveland, Ohio. Roger Elvik has never been to Ohio to do any of this material. The so-called charges are linked somewhat to the Ron Lutz case and Richard and Joe. And that whole sequence of what went down with the 18 of Ron Lutz's buddies that so-called came in and filed documentation and paperwork against the judges, the prosecutors, and the lawyers in the Ron Lutz case. And now it appears as though Elvik and Ron and Tom are being drug into this matter too. And in reality, they almost had zero or nothing whatsoever to do directly with any of the Ron Lutz matter, facts, or affairs. However, 8,300 forms. Does everybody in here understand what those are? Anybody not understand what they are? Okay, a whole group of people. Okay, an 8,300 form is a U.S. Treasury form. And it's a form that's being filed basically when there is reason to believe that some party has not paid a tax upon some kind of money received and could very well owe a tax or a return based on the money received and they didn't file. So it's a charging instrument. It's like telling the government, hello, I think we got some people out here that's cheating the IRS on taxes. I believe you've got to look into this party based on these transactions here and check it out. Now basically what Elvik and a lot of the other people were doing is if they were offered some kind of offering from a public official, and they came back and accepted the offering, the presumption is there's an agreement or a contract. And if the parties told the public official to settle and close the account and use the exemption of the living man for the payment of whatever that was, and then if the living man also issued a, what do they call the document that shows that you are the primary on the issuance of a credit? Yeah, it'll come to me in a minute. No, it's not a 1099 per se. That's when you're transferring a payment. It's a 1099 original OID form, which reports to the IRS that there's an original issue discount, and that if somebody else has picked up the value of that, and there's reason to believe they have not reported it, then an 8300 form to the IRS should get them to investigate it. The problem is, most of the time, when these 8300s were issued against public officials, it's assumed and presumed that it's an harassment of a public official interfering in his public duty and job to get him in trouble with other government officials. And so the 8300 forms have been turned around and used against these people as the source of criminal filings. And it appears as though that when it comes to the arrest of Roger Elvick in August of 2003, that it's his use of the 8300 forms on some of his commercial transactions that is the source of the so-called grand jury indictments in Cleveland